Good morning. I hereby call to order this 17th meeting of the Pennsylvania Public Utility Commission for the year 2016 and ask that you please rise for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Before we proceed with our meeting, I would like to take the opportunity to introduce a guest that we have with us today who is shadowing our Secretary, Rosemary Chiavetta. Her name is Sydney Baxter. She is a junior at the New Oxford High School, and she would like to be an attorney in the future. So we welcome Sydney to the PUC. So our first matter on this morning's agenda is the approval of the minutes for September 15, 2016. And I would turn to Vice Chairman Place, who is the editor.
Thank you. I've reviewed the minutes of the September 15, 2016 public meeting and move that they be approved as submitted.
We have a motion to approve the September 15, 2016 minutes. Is there a second?
Second.
Second by Commissioner Powson. Any discussion, any edits? Hearing none, all those in favor say aye.
Aye.
Any opposed? The motion passes 5-0. And now I will call up our Director of the Office of Special Assistance, Cheryl Walker-Davis, to lead us through today's agenda.
Thank you, Madam Chairman. Good morning, and good morning, Commissioners.
Good morning.
Good morning.
May it please this Honorable Commission, on behalf of your various offices and bureaus, we present for your consideration and disposition the following agenda items, commencing this morning with matters on behalf of the Office of Competitive Market Oversight, appearing on page 1. There are 3 separate recommendations and proceedings, all of which involve the company plans pertaining to implementation of web portal implementation standards, as well as proposed cost estimates and proposed recovery mechanisms. Those recommendations pertain to the Duquesne Light Company, Metropolitan Edison Company, Pennsylvania Electric Company, Pennsylvania Power Company, and West Penn Power Company, as well as PPL Electric Utilities Corporation, and it is recommended that the Commission adopt each recommendation there appearing.
Is there a motion to adopt the staff recommendations?
So moved.
There's motion by Commissioner Sweet, second by Commissioner Coleman. Any discussion? Hearing none, all those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
On page 2 of the agenda, continuing with matters on behalf of the Office of Competitive Market Oversight, it is recommended that the Commission adopt the Bureau's recommendation with regard to the Philadelphia Gas Works account number access mechanism to facilitate natural gas supplier access to PGW customer numbers.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Sweet. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning now to matters presented on behalf of the Office of Special Assistance, commencing on page 3 of the public meeting agenda, it should be noted that the first item pertaining to Core Communications, Inc. versus Verizon Pennsylvania, LLC, has been postponed until public meeting of November the 9th. It is recommended that the Commission adopt the recommendation next appearing in the matter pertaining to the PUC's Investigation and Enforcement Bureau versus Best Rate Limousine, LLC.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Powson. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
On page 4 of the public meeting agenda at the top, in the matter involving the formal complaint of Bonnie Roberts versus Verizon North, LLC, there is the motion of Commissioner Coleman as well as the statement of Commissioner Sweet.
Is there a motion to call up this matter for consideration?
So moved.
Is there a second?
Second.
Motion by Commissioner Powson, second by Commissioner Sweet. Under discussion, I would call on Commissioner Coleman for his motion.
Thank you, Chairman. I had asked that my motion be entered into the record as though I had read it in its entirety. Before the Commission for Disposition are exceptions filed by Verizon North to initial decision issued in a customer formal complaint proceeding. The complainant alleges that her telephone service provided by Verizon, quote, shorts out when she receives telephone calls. The initial decision sustained the complaint against Verizon and directed the following: a $2,000 civil penalty for failing to identify and correct the cause of the service problem and for providing confusing, inconsistent, and incorrect information to the complainant about the cause of the problem, and a $1,000 civil penalty for failing to have a manager contact the complainant about her service problems. Verizon accepts the finding of the unreasonable service and the $3,000 civil penalty. Upon review of the record evidence and the applicable law, I propose to grant Verizon's exceptions in part and deny in part. I agree with the initial decision that Verizon did not provide reasonable service here, although Verizon appears to have responded diligently to the customer service complaint. The fact remains that the service problem has persisted for 3 years. Moreover, Verizon did not successfully rebut the allegation that it is providing confusing information to the customer upon the cause of her service problems. In short, no customer should have a service problem for 3 years without the utility offering a solid explanation and solution. However, I do not agree that a civil penalty is warranted in this case under our standards for determining civil penalties. Therefore, I propose to grant Verizon's exception to the $2,000 civil penalty. For one, Verizon provided credible evidence that the customer is at least partially responsible for how long the service problem has persisted. The customer service problem is likely caused by something inside the customer's home, but the customer refuses to accept Verizon's offer to inspect her inside facilities and equipment at no charge to her. In my view, the customer's refusal to accept Verizon's offer mitigates against a civil penalty. Moreover, the testimony that Verizon provided confusing information about the cause of the service problem, while sufficient to support a finding of unreasonable service, is insufficient to support a civil penalty. Also, I propose to grant Verizon's exception and reverse the $1,000 civil penalty for failing to have a Verizon contact the complainant. Notwithstanding that there is no law, regulation, or commission order requiring a Verizon manager to contact the customer upon request, the credible record evidence shows that several Verizon managers contacted the complainant on different occasions about her service problem. Therefore, I move that the exception to Verizon North LLC are granted in part and denied in part consistent with this motion. The initial decision is modified consistent with the motion, and that the Office of Special Assistants prepare an opinion and order consistent with this motion.
You've heard the motion of Commissioner Coleman. Is there a second?
Second.
There's a second by Vice Chairman Place. Under discussion, I will call on Commissioner Sweet for his statement.
Thank you. Before joining my staff as legal counsel, Regina Matz was working in the Office of Special Assistants and worked on this case. Please note she has not advised me on this matter.
Thank you. Anything under further discussion on the motion? Hearing none. All those in favor of the motion, say aye.
Aye.
Any opposed? The motion passes 5-0. On the matter as amended by Commissioner Coleman's motion, if there's no objection, we'll take the previous roll call. The matter passes 5-0.
It is recommended that the Commission adopt the staff recommendation in the proceeding involving the application of Burgett's Electric City Taxi, Inc.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second?
Motion by Commissioner Powelson, second by Commissioner Coleman. Is there any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
It is recommended that the Commission adopt the staff recommendation with regard to the joint petition for settlement in the proceeding involving the Bureau of Investigation and Enforcement versus Pico Energy Company pertaining to the natural gas explosion in Coatesville, Pennsylvania, noting your statement, Madam Chairman.
Is there a motion to adopt the staff recommendation?
So moved.
I heard a joint down.
Second.
They're so gracious. They're both trying to either move or second. So motion by, I heard Commissioner Powelson first, second by Vice Chairman Place. And under discussion, I would like to read a statement. On July 17, 2014, when PECO Energy Company performed an uprating project in Coatesville, a home exploded. Thankfully, no one was injured. Our Bureau of Investigation and Enforcement investigated the matter and revealed that the problems with the accuracy of PECO's maps of its service territory led to this incident. Before the Commission for consideration and disposition is the joint petition for settlement filed by BINE and PECO. The proposed settlement provides that PECO will develop a $3 million gas mapping plan, which will allow it to map and locate its facilities with sub-foot accuracy. PECO will spend an additional $2.3 million on related infrastructure improvements. The remapping of the service territory will take 10 to 20 years. PECO will also pay a civil penalty of $900,000 not to be recovered in rates. I believe that the work which PECO will undertake as a result of the settlement is critical for public safety. Because this work is so essential, I do not understand why it should take up to 20 years. That's my concern. So I do urge PECO to narrow its timeline and carry out this work as swiftly as possible. Any further discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Continuing with the presentation of agenda items, it is recommended that the Commission adopt the items pertaining with, commencing with that in the proceeding involving Burgess Electric Taxi, Inc., and all of the matters,
No, you've.
oh, I'm sorry,
Page 5.
page 5. Forgive me, Madam Chair. In omnibus fashion, it is recommended that the Commission adopt all of the items commencing with the recommendation in the proceeding involving Matthew and Tracy Kolar versus West Penn Power Company, as well as the remaining item on page 5, as well as all items on pages 6, 7, and the first item through and including the first item at the top of page 8, which starts at the bottom of page 7 and is labeled Joseph L. Rago versus Philadelphia Gas Works.
Do I have a motion to adopt the staff recommendations?
So moved.
Second.
Motion by Commissioner Powelson, second by Commissioner Sweet. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
And we also recommend the adoption of the matter in the proceeding involving the Keystone Taxi Service LLC application for call and demand service.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
We do recommend the adoption of the staff recommendation in the formal complaint proceeding involving Billy Joe Knapp versus Pennsylvania Electric Company, noting the statement of Vice Chairman Place.
Is there a motion to adopt the staff recommendation? Is there a second?
Second.
Motion by Commissioner Sweet, second by Vice Chairman Place. Under discussion, I would recognize Vice Chairman Place.
Thank you. Madam Secretary, I request that my statement be entered into the record as if I've read it in its entirety. Before us for consideration are the exceptions of the complainant, Billy Joe Knapp, to the initial decision issued on April 7, 2016. On October 30, 2016, Ms. Knapp filed a formal complaint against Penelec requesting an affordable payment arrangement as she receives only $725 per month from her disability benefits. She's also requested to be placed in the company's customer assistance program and has asked that her service not be terminated. Penelec has acknowledged that the complainant was sent a termination notice for the past due amount of $716.43, but did not terminate service because of the filing of the complaint. Penelec indicated that a payment arrangement had previously been granted by the Commission, that Ms. Knapp defaulted on the payment due to non-payment. Also, the company asserted that Ms. Knapp was previously enrolled in CAP, but was removed due to her failure to recertify her eligibility. Further, Penelec indicated that the complainant would need to pay her entire outstanding balance as she had already received the one-time benefit of arrearage deferral. In addition to Ms. Knapp's case, there are other cases before us today, such as Rago versus Philadelphia Gas Works, and Matthew and Tracy Kolar versus West Penn Power Company that draw attention to the hardship and dire circumstances faced by far too many of our fellow citizens who have profound difficulties paying for basic utility services. The struggle to maintain essential utility services impacts the fundamental needs of families to stay in their homes, to work, to go to school, and to participate in the communities throughout the Commonwealth. In addition, the lack of utility service may well lead to unsafe living conditions. I do not draw attention to these cases to imply a lack of concern or effort on the part of these utilities. In fact, there is much to commend in the substantive efforts made by regulated utilities and social service organizations through statutory and voluntary programs to provide assistance to low-income and payment-troubled customers. I'm also keenly attentive to the obligatory reciprocatory, I'm struggling with the
Need another syllable.
reciprocity, thank you very much. English language is sometimes a lot rather complex. All right. Obligatory reciprocity for utilities to render service and for customers to provide payment. However, to further the public interest, as we are mandated to do, more should be done to permit Pennsylvanians to maintain essential utility services. In particular, I believe that the large lump sum payments required to reconnect essential utility services are all too often out of reach for many low-income, payment-troubled Pennsylvanians. I remain concerned that we are regulating residents to a permanent inability to access, God, I'm having troubles today, essential utility services. These are all too common cases must compel all of us to further address the arrearage and payment challenges of utility customers and to contribute to the maintenance of essential utility services. For example, the Commission's energy burden guidelines, which are used to determine payment affordability, are antiquated, unsupported by sufficient analysis, and fail to account for regional climatic heterogeneity. They simply need updating. Also, greater education and coordination efforts among all parties can also assist in alleviating much of the existing hardship. Some education and coordination steps are taking place that can be done. Although it may require regulatory and statutory change, I suggest it is likely that there are novel policies that would further assist in mitigating these challenges. If further solutions can be crafted to more thoroughly address disconnection of essential utility services for low-income and payment-troubled customers, substantive benefits accrue not only to the affected customers, but to the utilities, ratepayers, and communities throughout the Commonwealth. Thank you.
Thank you, Vice Chairman Place. Any further discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning now to page 9 of the agenda, it is recommended that the Commission adopt the staff recommendation in the proceeding involving the PPL Electric Utilities Corporation Default Service Plan Number 4, noting your statement, Madam Chairman, as well as the statements of Commissioner Powelson and Commissioner Sweet.
And Vice Chairman Place.
Vice Chairman, please.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Under discussion, there was motion by Commissioner Coleman, second by Commissioner Sweet. Under discussion, let me call on Commissioner Sweet first.
Yeah, before joining my staff as legal counsel, Susan Colwell was working in the Office of Administrative Law Judge and worked on this case in her capacity as an ML judge. Please note she has not advised me on this matter.
Under discussion further, I will call on Vice Chairman Place.
All right. Thank you. We'll see if I can get through this one without tying myself in a knot. Madam Secretary, I would like my statement to be entered into the record as if I'd read it in its entirety. Before us for consideration is a petition for approval of the default service program for procurement plan for the period June 1st, 2017 through May 31st, 2021, and the joint petition for approval of partial settlement at this docket. Also for our consideration, the exceptions of PPL, Electric Utilities Corporation, and Retail Energy Supply Association, and PPL Industrial Customer Alliance, filed in September 2016 to the initial decision in this case. First, I fully support approval of the partial settlement reached in this proceeding. The parties are to be commended for their collaborative work to craft a resolution of the vast majority of issues in this very complex case. Their work product will serve the general public well. However, I wish to express concerns regarding the shopping restrictions imposed on customers served under our. All right, does someone want to come up here and do this for me?
I'm just glad I'm not the only one that has
Right?
problems.
I'm dyslexic, and I will struggle with this one. Under our Customer Assistance Program, or CAP, I'm not able to support the joint litigation position, which severely limits the ability for CAP customers to avail themselves of competitive market products. The outlined restrictions will likely force all CAP customers to return to default service over time. My concerns are as follows. First, it is unlikely that EGSs will participate in the CAP SOP program as articulated by EGSs on the record in this case. Second, the order inappropriately limits shopping only to the CAP SOP program. Thus, customers seeking offers from EGSs below the current default service price, even products that offer prices for multiple years, will not be able to lock in and hedge low market priced fixed rate products. Third, such rigid rules will not allow EGSs and customers to participate in spot market priced products that over time may be priced well below hedged default service products. Fourth, CAP customers will not have access to new innovative EGS products that may help them better control their energy costs. I hope that future proceedings will provide us with solutions that will provide CAP customers with more substantive access to a range of competitive market products while remaining cognizant of the market risk exposure. Some solutions might include a new non-CAP SOP contracts should include fixed offers not to exceed the default service price at time of offer. After expiration of the fixed rate period, the same limitation should apply. The new offered rate would need to be at or below the then current default service price. Second, new non-SOP contracts that are variable rate offers should require the 6th consecutive month average rate to be below the 6-month average rate for default service rate, a rolling 6-month average test. Third, the post-SOP rollout option that should be limited to meet the same rolling 6-month average test. If the EGS is unable to accomplish this, it would immediately return the customer to default service or have the customer sign up for the SOP program or another fixed rate EGS contract at or below the current default service rate. Fourth, any existing fixed rate contract or any rollover contract option must meet the same requirements. This should not be viewed as an exhaustive list of alternative shopping restrictions, but provide concepts that respond more appropriately to the CAP customer issues identified in this case. I fear that the CAP customer resolutions proposed will cause more long-term harm than good. Therefore, I concur in part and dissent in part. Thank you.
Thank you, Vice Chairman Place. Commissioner Powson.
Thank you, Madam Chair. I'll be brief here in my 3-page statement, but before the Commission here this morning are the exceptions and reply exceptions to the initial decision regarding PPL's petition for approval of its default supply plan for the calendar year June 11, 2017 out to May 31st of 2021. And while I support the partial settlement here this morning, I do not agree with the parties' resolution of the remaining issues, which was whether the customer who participates in the PPL's CAP program should be permitted to shop for an electric generation supply. During the course of the litigation, all the parties, except RESA, reached an agreement on the CAP shopping issue. These parties proposed to limit the ability of CAP customers to shop for electric generation supply offers unless they do so through PPL standard offer program. And I think Vice Chairman Place alluded to some of the potential market inequities that could take place as a result of today's decision. Under the price to compare, which will be a 12-month fixed product, there is a concern, again, that some of these market inequities could create an environment where customers opt not to go out and shop in the market. There is no disputing that universal service costs are rising, and I just want to throw out here today, maybe that's something we as a commission working in collaboration with the Office of Consumer Advocate can work, and also with the Pennsylvania Energy Association, have a discussion, a broader discussion about rising universal service costs and how we remedy that going forward. However, the solution developed by the parties in this proceeding is not the correct answer to this problem. Limiting the ability of PPL's approximately 41,000 capped customers to choose a supplier and have control over their electricity costs is a drastic step that should not be undertaken lightly. And I note, if you look at what this commission has done prior and post rate cap expirations, I think we've done a remarkable job providing consumers the peace of mind that we have consumer protections in place. And then you fast forward to the events of the polar vortex, greater notification of contracts, and providing another added level of benefit, coupled with the great work done by our Office of Communications and our staff with consumer education. I firmly believe that these customers have the ability now to go out in a very transparent market and shop for generation supply. And I've consistently disagreed with those who don't believe that this system is working. Let me conclude here this morning, Madam Chair, by saying that the staff is recommending that we refer the issues of the rising universal service costs and the complex role of cap shopping to the Office of Competitive Market Oversight. And I agree strongly with this recommendation, and I believe that we should give the Office of Competitive Market Oversight a chance to address this issue on a statewide basis before approving on a case-by-case basis proposals to limit cap shopping. I should note back in 2011, this same company was strongly considering a movement to petition the Commission to end their default supply obligations as we know it, which would have been an interesting discussion here today. But again, restricting cap customer shopping in the PPL service territory alone will result in piecemeal solution to the problem rather than dealing with a more holistic approach. For these reasons, Madam Chair, I'll vote yes to approve the partial settlement, but respectfully dissent on the cap shopping issue.
Thank you, Commissioner Powelson. And I also do have a statement, and mine does not refer to the CAP program whatsoever, just so everyone knows. Before the commission is for consideration and disposition is the petition of PPL's default service program for the period June 1st, 2017 through May 31st, 2021. On July 19, 2016, the parties to this proceeding filed a joint petition for partial settlement. On August 17, 2016, the presiding administrative law judge issued an initial decision recommending approval of the partial settlement as modified in the initial decision. Exceptions and reply exceptions to the initial decision were filed on September 6, 2016 and September 16, 2016, respectively. Consistent with my position on previous default service filings, I wish to elaborate why I believe this partial settlement does establish a default service plan that satisfies the procurement requirements under Act 129, specifically Section 2807E of the Pennsylvania Public Utility Code. This section provides that a default service provider must procure electric power via a prudent mix of spot market, short-term and long-term contracts designed to ensure adequate and reliable service at the least cost to the customers over time. PPL's proposed default service program includes short-term products in the residential and small commercial and industrial portfolios, spot market purchases in the large commercial and industrial portfolio, and long-term contracts in the residential portfolios. I note that none of the default service plans that I have voted on during my tenure include new long-term contracts, only long-term contracts inherited from previous default service plans. The instant proceeding is no different. Since these grandfather contracts will eventually expire, in my opinion, it will be incumbent upon electric distribution companies and this commission to carefully consider long-term contracts of 4 to 20-year terms consistent with Section 2807E of the code in the future default service plans unless the legislature decides otherwise. Are there any further comments?
Yes, I'd like to associate myself with Commissioner Powelson's statement, please.
Thank you, Vice Chairman Place. So, in taking the vote, I know we have two commissioners that have made statements that they agree with part of the proposal and dissent in the other part of the proposal. There has been no motion to split the question. So in fashion that we have inherited over the years at the commission, I would ask when you cast your vote, you will note whether you're casting it yay and just dissenting in part, as we've always done. Hearing that, all those in favor say aye.
Aye.
Aye. And any opposed?
Opposed.
Opposed.
We're having full dissent or
You
partial
can't
dissent?
bifurcate the question. You can't break it out, so we have to vote no. I think it's
What
You
we
can
have done in the
bifurcate.
past, and this I'll take as part of the
dissent?
discussion, what we have done in the past is noted that there was a partial dissent, but you voted either in favor in full or dissent in full. I am giving you the option to do that now.
May I approach
I
the
would
bench?
ask, yeah, I'd ask that we have
Go at ease,
parliamentary
please.
procedure here.
We'll go at ease. Going back on the record, on the matter of PPL electric utility companies, on the vote. All those in favor say aye.
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 Aye. And we know that we have two partial dissents, so I believe in our
Yeah, I would
conversation, state
say-
your purpose.
Jump in. Yes with a partial dissent.
I will concur. And a yes and a partial dissent.
So-
And Madam Chair, let me apologize for the confusion
Okay.
brought up on this case.
I love parliamentary procedure. I really do. So the vote is 5-0, noting the two partial dissents of Vice Chairman Place and Commissioner Powelson per their statements made on the record. Thank you.
Continuing with the presentation of public meeting agenda items and matters on behalf of the Bureau of Technical Utility Services, it is recommended in omnibus fashion that the commission adopt the items, commencing with that at the top of page 10 in the matter labeled electric generation supplier license cancellations, and continuing with the remaining items on pages 10, 11, and 12 through and including the recommendation at the bottom of page 12 in the proceeding involving the Maple City Transit, Inc. increase in rates.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second? Motion by Commissioner Powelson, second by Commissioner Sweet. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
It is recommended that the commission adopt the Bureau of Technical Utility Services recommendation with regard to the quarterly earnings of Pennsylvania utilities, noting the statement of Commissioner Powelson.
Is there,
And a statement by.
And the
Commissioner Place.
statement of Commissioner Place. We did not get your two statements.
Sorry.
is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Powelson. Under discussion, I will call upon Commissioner Powelson for his statement.
Thank you, Madam Chair. Before the commission this morning for consideration is the Bureau of Technical Utility Services report on quarterly earnings of jurisdictional utilities for year ending June 30th, calendar year 2016. As part of the QER, the commission determines the return on equity that will be applicable for those utilities that implement a distribution system improvement charge, but have not had a rate case within the past 2 years. My position is the commission should not change the ROEs for this quarter, and let me explain why. The ROEs in the QER are important because they directly impact the utility's ability to implement the DISC mechanism. As a preliminary matter, it is important to recognize that the DISC mechanism does not require customers to pay more over the life of a capital asset. The timing of recovery is the only factor affected. In fact, as a result of this mechanism, we have really basically eliminated regulatory lag for our utilities, and in lieu of that, created an environment where we've had accelerated deployment of capital into distribution systems. In this way, the DISC mechanism is very customer-friendly. As a result of it, creates rate gradualism, and it helps to insulate customers from rate shock in the wake of a utility rate case by allowing utilities to gradually fund necessary upgrades to the system. DISC also provides an immediate benefit to customer safety and the quality of service by encouraging our utilities to maintain and upgrade their systems at an accelerated pace. And keep in mind, as part of these DISC plans, our utilities are now required to submit long-term infrastructure plans that are approved by this commission. If the commission truly places a high value on, on the accelerated replacement of aging infrastructure, then we should set ROEs in a manner that will encourage utilities to engage in this important work. Along those lines, I believe the commission should keep the following principles in mind when setting ROEs in the DISC mechanism. First, I believe that DISC ROEs should generally exceed staff markets-based equity calculations by a healthy margin. Setting the DISC ROE at a rate that is equivalent to or slightly above the staff's calculation places an unnecessarily tight collar on the DISC mechanism, thereby discouraging capital formation and investment. Over the last 5 quarters, the commission has reduced the DISC ROE even when market rates have steadily or even increased. For example, in the electric industry, we have dropped the DISC return consecutively over the last 3 quarters by 35 basis points, and now at least one company is at risk of losing their DISC recovery mechanism. This is clearly problematic. We need to maintain DISC ROE at a healthy margin above market rates in order to encourage capital investment. Second point we'll mention here this morning is regulatory certainty should be a key factor in our analysis here this morning. It is crucial that the Commission not only set appropriate ROEs, but take a deliberate approach to changing these numbers. The DISC returns have traditionally been very stable over the period that this statute has been in effect, basically at a level of 10-to-1 to 10.2%. These rates have now been subject to a serial quarterly reductions, even where the market indicated rates have been increasing. This is not a good trend for utilities looking to invest capital in Pennsylvania. If you look at a lot of the structures of the utilities we regulate at the holdco level, meaning the parent, they are in multiple state jurisdictions. So as a result of that, if we continue to see downward pressure on ROEs, that incremental capital investment will go to those other areas that reward it. And that's basic rate making 101. Instead of making incremental changes to the ROE, the Commission should view the returns over the long term and better understand temporary market fluctuations before reacting to them. The calculations of market-based return will invariably fluctuate from quarter to quarter. That is a given. But it is important for the Commission to take a measured approach to these changes. Rate making, as I just mentioned, is art-based on science, and determining ROEs is always a complex and challenging process that involves weighing a variety of factors. Another point I'll make here this morning is we should resist the temptation to set an ROE for DISC purposes that varies across industry sectors. This is counterproductive on so many levels. Historically, industries that are eligible for DISC treatment have varied by only 10 basis points. Now we are starting a range by 25 basis points between industries, gas and electric in this instance, which is more than anticipated. It is much more administratively efficient, I believe, to have one unified number instead of a wide divergence among companies that are dipping into the same capital pools. In summary here this morning, I do not believe the downward pressure that the Commission has been placing on ROEs recently should continue. I am concerned that if these numbers continue to go lower, it could jeopardize a utility's ability to invest in infrastructure replacement, which is an important safety issue for the Commonwealth. Moreover, the reductions in ROEs will not go unnoticed by investor-owned utilities that require capital formation through the markets. I support gradualism and caution that making ROE changes are not in the best interest of not only the public interest, but our ability to, again, retract and retain competitive capital across these multiple jurisdictions. And finally, I believe the Commission should continue to watch these trends in the market before making any more modifications on the quarter ROE adjustments. Thank you, Madam Chair.
Thank you, Commissioner Powelson. Vice Chairman Place.
Thank you. If you allow me one more attempt to speak from the bench this morning. I might blame that we're approaching Halloween for my verbal contortions this morning. The Commission's quarterly report continues to move electric and water quarterly ROE values downward, given the fundamentally low financial return metrics. While we are not proposing any adjustments for the natural gas ROE, I continue to support gradual downward movement of those values so as to be more reflective of the fundamental return models. Thank you.
Any further discussion? Hearing none. All those in favor say aye.
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 Any opposed?
No.
No.
The motion passes 3-2, noting the dissent of Commissioner Powelson and Commissioner Sweet.
Turning now to matters presented on behalf of the Law Bureau, commencing on page 14 of the public meeting agenda. It is recommended that the Commission adopt the Law Bureau's recommendation appearing at the top of page 14 into proceeding labeled Implementation of the Alternative Energy Portfolio Standards Act of 2004 and revisions to Commission regulations pertaining to the net metering, interconnection, and compliance provisions of the Alternative Energy Portfolio Standard Act, noting your statement, Madam Chairman.
Thank you. Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Powelson, second by Commissioner Sweet. And I do have a statement. Let me just start off by saying what a great job that our staff has done. They've worked on these regulations for numerous years, even right when I was starting on as a commissioner, right before I was starting on as a commissioner. Today, we revisit the revisions to our net metering and interconnection regulations pursuant to the Alternative Energy Portfolio Standards Act, or AEPS. The revision to the definition of utility included in this iteration of the regulations is an effort to accommodate the concerns voiced by the Independent Regulatory Review Commission, the Office of the Attorney General, and stakeholders in the rulemaking process. I believe that the revised definition of utility is consistent with the Act and is in the public interest. I also wish to state for the record that the revisions made to these net metering regulations are not an attempt to address any court challenges currently being made regarding net metering tariffs or rules, for the very reason that they are ongoing and are not yet resolved. Any further discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
It is recommended that the Commission adopt the Law Bureau's recommendation in the matter involving the petition of the Billtown Cab Company, Inc.
Is there a motion to adopt staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Powelson. Any discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0.
It is recommended that the Commission adopt the recommendation of the Law Bureau in the matter involving the rulemaking to reduce entry barriers by passenger motor carriers by eliminating the requirement that they demonstrate that the application will serve a useful public purpose responsive to a public need, noting the joint statement of Commissioners Powelson and Commissioner Coleman.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Powelson. Under discussion, I will call on Commissioner Powelson for the joint statement.
Thank you, Chairman. Before the Commission this morning for consideration and disposition is the final rulemaking order amending several of the Commission's regulations to reduce barriers to entry for passenger motor carriers. And let me also take this opportunity to thank Commissioner Coleman and my colleagues. This has been a long road to hoe, getting this rulemaking ready for today. And it certainly couldn't happen without the work of our Transportation Bureau and as part of our collaborative known as Transportation 2.0. The rulemaking order specifically reduces current barriers to entry by eliminating the requirement that an applicant for passenger motor carrier authority establish that approval of that application will serve a useful public purpose responsive to a public demand or need, otherwise known as the need requirement. And we're going to have a little trivia question here at our next PUC event: when the need doctrine was adopted. Judge Rainey, I think you might know that what century it was adopted in. The elimination of the need requirement for passenger carriers highlights the Commission's efforts to ensure regulatory flexibility in light of the changing transportation landscape, which we all know a little bit about here these days at the Commission. Due to increased competition in the motor carrier industry, the need requirement has become clearly an outdated doctrine. Instead of serving a useful purpose, this requirement posed an obstacle to otherwise viable applicants and serve to protect monopoly interests to the detriment of healthy competition. And the Commissioner Coleman and I were reminiscing back to our chamber days, Madam Chair, yesterday, and he's got some long, fond memories of going before the Public Utility Commission on behalf of an applicant and running into the need doctrine. So it's taken a little while to get here, but I think at the end of the day, it is the right decision to make, and it's important to note that with the elimination of the need requirement, the Commission will continue to ensure that passenger carriers are technically, financially fit, and can operate safely and legally here in the Commonwealth of Pennsylvania. Passenger carriers must provide, as we all know, service that is safe, reliable, and fully insured. The elimination of the need requirement will simply provide consumers with more choices and more competition among passenger carriers. And I think, again, another very positive outcome this morning in terms of the approval of this rulemaking. Thank you, Madam Chair.
Thank you, Commissioner Powelson. Any further discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Continuing with matters presented on behalf of the Law Bureau, now on page 15 of the public meeting agenda, at the top, it is recommended that the Commission adopt the Law Bureau's recommendation in the matter pertaining to the petition of Newster, Inc., pertaining to the appropriate form of area code relief to be provided for the 717 area code.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Powelson. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
And it is recommended that the Commission adopt the recommendation of the Law Bureau in the matter pertaining to the implementation of Section 1329 of the Public Utility Code pertaining to the valuation of the assets of municipal and authority-owned systems that are acquired by investor-owned systems.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Powelson, second by Vice Chairman Place. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning now to matters presented on behalf of the Office of Administrative Law Judge, commencing on page 16 of the public meeting agenda, it is recommended that the Commission adopt A.L.J. Jones's recommended decision in the matter involving the Norfolk Southern Railway Company and Montgomery County.
Is there a motion to adopt staff recommendation?
So moved.
Is there a second?
Second.
Motion by Coleman, second by Commissioner Powelson. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Should be noted that the next matter pertaining to the complaint of John J. Rounce versus Pico Energy Company has been postponed until public meeting of November the 9th. With regard to the complaint of Neil and Gilda Altman versus Verizon Pennsylvania LLC, there is the motion of Commissioner Coleman as well as the statement of Commissioner Coleman.
Is there a motion to call up this matter for consideration?
So moved.
Is there a second?
Second.
Motion by Commissioner Powelson, second by Commissioner Sweet to call up this matter for consideration. Under discussion, I will call on Commissioner Coleman for his motion.
Thank you, Chairman. I'd ask that my motion be entered in the record as though I read it in its entirety. Before the Commission for Disposition, its initial decision issued in the above captioned formal complaint of Neil and Gilda Altman versus Verizon Pennsylvania LLC. The initial decision sustains the complaint in part and finds that Verizon's conduct in this case violated the Commission's regulations and the Public Utility Code. I agree with the findings in the initial decision and move that the decision be adopted. However, I note that the total civil penalty recommended in the initial decision is $4,750, not $3,750 as erroneously stated in the initial decision. Therefore, I move that the initial decision be modified consistent with this motion, and the Office of Special Assistant prepare an opinion in order consistent with this motion.
You have heard the motion of Commissioner Coleman. Is there a second?
Second.
Second by Vice Chairman Place. Under discussion, hearing none. All those in favor of the motion say aye.
Aye.
Any opposed? The motion passes 5-0. Without objection, we will take the previous roll call on the matter as amended by the motion. Motion passes 5-0. Oh, you have a statement.
I do have a statement.
Sorry.
That's okay. That's okay.
Already won.
Okay. Well, if I may, Madam
You
Chair.
may. I apologize.
I'll ask that my statement be entered into the record as I read it in entirety, and I will be brief here this morning, but there were a couple of matters that I thought were worth mentioning beyond the fine correction in the motion. This is a quality of service complaint about the customer's copper service that has been provided by Verizon. The complainant also objects to the conversion of their telephone service from a copper to a fiber-based service. My statement notes that I agree with the initial decision, including the decision to deny the complainant's request to restore their copper wire service from Verizon. In short, I agree that no Pennsylvania law, regulation, or order grants the Commission the authority to require Verizon to restore copper-based service as the complainant has requested. My statement also notes that I agree with the initial decision that Verizon did not communicate reasonably with this customer about the company's network transformation. Verizon's network transformation involves migrating all Verizon customers in a particular wire center from a copper-based service to a fiber-based service. Although this may be of little comfort to the complainants, I expect that this case is to serve as a lesson learned for Verizon, that going forward, the communication failures that occurred here do not occur as Verizon continues with its network transformation in Pennsylvania. Thank you, Madam Chairman.
Thank you, Commissioner Coleman, and just let me reiterate for the record, do apologize for not acknowledging you for your statement before we took the vote, but we did vote, and the motion is 5-0.
Continuing now on page 17 of the public meeting agenda and additional matters pertaining to the Office of Administrative Law Judge, it is recommended that the Commission adopt ALJ Heap's initial decision in the complaint proceeding of Nicole Dorsey versus PUC Energy Company.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Powelson, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0.
It is recommended that the Commission adopt ALJ Dunderdale's recommended decision to approve the settlement without modification in the matter involving Columbia Gas of Pennsylvania, Inc.'s general rate increase proceeding.
Is there a motion to adopt the recommended decision?
So moved.
Is there a second?
Second.
Don't be shy, guys. Motion by Commissioner Powelson, second by Vice Chairman Place. Under discussion, I would like to just commend Columbia for its large customer incentive proposal. This mechanism will permit large customers an option to pay the cost of line extensions over time through an increase in charges to the customer's bill. As many know, the upfront cost for the extension of gas service can often be prohibitive. Availing customers, including large commercial customers and industrial customers, alternative options to finance extensions will help expand access to natural gas, which is a policy that I continue to support. So I do want to commend Columbia for this proposal. Any further discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
In the matter pertaining to ALJ Gould's initial decision in the complaint proceeding of Marie Keats versus UGI Utilities, Inc., there is the motion of Commissioner Sweet.
Is there a motion to call up this matter for consideration?
So moved.
I heard Commissioner Coleman first, but I also heard Commissioner Powelson, so I will take him as the second. Under discussion, I will call under Commissioner Sweet for his motion.
Thank you, Madam Chair. Excuse me. I ask that the entire motion be placed upon the record as if I had read it in its entirety. Before the Commission is an initial decision sustaining the preliminary objections filed by UGI Utilities, Inc., and dismissing the formal complaint of Marie Keats without prejudice. I am moving that the initial decision be reversed and the matter remanded for additional proceedings. There are a number of abnormalities in this case which have caused the proceedings to become muddled. Sending the case back to its beginning will rectify those abnormalities and ensure that the complainant is afforded the due process to which she is entitled. Therefore, I move that the initial decision in this case is reversed and that the complaint be reinstated. 2, that the Secretary serve the Commission's order in this matter and complaint on PUC Energy Company and begin the case over with both PUC and UGI Electric Division as named respondents. That the preliminary objections of UGI Utilities, Inc. are denied. Number 4, that OSA prepare an order consistent with this motion. Thank you.
You have heard the motion of Commissioner Sweet. Is there a second to the motion?
Second.
Second by Vice Chairman Place. Any discussion on the motion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0. On the matter as amended by the motion, if there's no further discussion and no objection, we will take the previous roll call. Hearing none, the motion passes 5-0.
On page 18 of the public meeting agenda, it is recommended that the Commission adopt ALJ Haas's recommended decisions in the first 3 proceedings pertaining to UGI Utilities, Inc. Gas Division, UGI Central Penn Gas, Inc., and UGI Penn Natural Gas, Inc., and their purchase gas cost rate requests, noting the combined statements of Vice Chairman Place with regard to the proceedings involving UGI Utilities, Inc. Gas Division and UGI Central Pan Gas, Inc., as well as the individual statement of Commissioner Sweet with regard to each of those proceedings.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Powson. I would recognize Commissioner Sweet first for his statement.
Thank you. And Madam Chair, I guess I apologize to the Commission for having plundered the workforce so much that I have so many of these conflict statements. But let me make this one for all three of the matters on page 18, UGI Utilities, UGI Central Penn Gas, and the second UGI Penn Central Gas, that before she joined my staff as legal counsel, Susan Cowell was working in the Office of Administrative Law Judge and worked on all three of these cases in her capacity as an administrative law judge. Please note that she has not advised me on any of these matters.
Thank you. Vice Chairman Place for your statement.
Thank you. Madam Secretary, I request that my statement be placed in the record as if I had read it in its entirety. Before us for consideration are the UGI Utilities Incorporated Gas Division and UGI Central Penn Gas Incorporated annual purchase gas cost tariffs. For both of these cases, joint petitions for full settlement were submitted by the parties and supported by the recommended decisions of the administrative law judge in the consolidated litigation. A provision of the settlements involves the long-term release of upstream capacity on the A&R pipeline. Under the terms of the settlements, the parties agreed to apply the 75% revenue sharing mechanism in its tariff to the release of firm transportation capacity on the A&R pipeline. While I am disinclined to upset the overall benefits and balance of the settlement, noting that the companies may have provided other values to offset this concession on the part of the Commission's Bureau of Investigation and Enforcement, I wish to express my concern regarding revenue sharing of long-term capacity releases. Such upstream capacity assets often have no current, substantial, used, and useful purpose, and customers who bear the full cost of this capacity should not be required to share revenues with the companies for assets that have de minimis long-term or seasonal value to PGC customers and natural gas suppliers. I'm voting to support the overall settlement while respectfully expressing my concern regarding revenue sharing of long-term capacity releases. Thank you.
Thank you, Vice Chairman Place. Any further discussion on these three cases before us? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
It is recommended that the Commission adopt ALJ Barnes's initial decision in the proceeding involving the complaint of Kathy Gatto versus Columbia Gas of Pennsylvania, Inc.
Is there a motion to adopt staff recommendation?
So moved.
Second.
It's a motion by Vice Chairman Place, second by Commissioner Powson. Any discussion?
Place.
I'm sorry. I'm going to redo this. It's a motion by Vice Chairman Place, second by Commissioner Coleman.
Was not involved.
Always thinking of you, Robert. Sorry about that. I appreciate it. Any discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0.
Madam Chairman and Commissioners, that concludes the presentation of regular agenda items. Turning now to the carry-in agenda. It is recommended that the Commission adopt the recommendation of the Bureau of Technical Utility Services in the matter involving the joint petition of Consolidated Rail Corporation pertaining to Stone Bridge at crossing number 10, noting the statement of Commissioner Sweet.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Powson, second by Commissioner Sweet. Any discussion? Under discussion, let me call on Commissioner Sweet for his statement.
Once more with emphasis. Before joining my staff as legal counsel, Susan Cowell previously held a position in the Commission as an attorney during which she was assigned to this matter. Please note she has not advised me in this matter. As a further footnote for the Commissioners, I would assure you that there were matters this month that Susan Cowell did provide services. Thank you.
Thank you, Commissioner Sweet. Any further discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
It is recommended that the Commission adopt the Bureau of Technical Utility Services recommendation in the application proceeding of PennDOT pertaining to the Conchester Road where it crosses above grade the track of SEPTA.
Is there a motion to adopt the proposed order?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Powson. Let me get this right. Any discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0.
And it is recommended that the Commission adopt the Office of Administrative Law Judge recommendation, specifically ALJ Barnes's and Haas's recommended decision approving the settlement and the proceeding involving the application of Pennsylvania American Water Company to acquire the water and wastewater collection and treatment system assets of the Borough of New Cumberland.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Sweet. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Madam Chairman and Commissioners, I am pleased to say that that concludes the presentation of public meeting agenda.
A lot of gremlins today.
We did have a lot of ground to cover. I do thank the staff for all their hard work and the commissioners for all their comments, statements, motions, and everything else. But I would be remiss if I did not conclude our meeting before we adjourned with the important message that we have been giving concerning our Prepare Now program. This is our 14th year with our Prepare Now education efforts. The PUC today is urging our utilities to take extra steps to help consumers, especially those on limited and fixed incomes, to prepare for winter heating costs. A letter has been signed by myself and my fellow commissioners, which has been sent to all of our Pennsylvania electric and natural gas utility companies under the PUC's jurisdiction. In this letter, we encourage them to join the commission in educating consumers about the many winter assistance programs and the services that are available to them. The letter also includes specific suggestions for our utility companies and emphasizes that they have more flexibility to make allowances for payment-troubled customers than the PUC does under the law. The letter also includes, in commencing our 2016 Prepare Now campaign, we are focusing on educating consumers about the availability of low-income programs to them, about also increasing their awareness of ways to reduce winter heating costs, educating them on energy conservation, and encouraging them to check electric and natural gas bills as well as their supplier contracts, and informing consumers about our PAPowerswitch.com and our PAGasSwitch.com website, which has resources for them to shop. Many utility customers who need assistance are still unaware of the programs that are available to help them to restore or maintain their utility service. Just as the Commission will be reminding consumers who call us about the availability of such programs, we urge all of our utilities to increase their outreach efforts to make sure that the consumers receive information about any program which they may be eligible for. We look forward to hearing the responses from the companies on how they plan to assist consumers this winter. And with that, I would say thank you very much. And if there are no additional comments from our commissioners,
Could I?
Vice Chairman Place.
Right.
I'm looking.
Sorry. Yeah. I just wanted to add on to the chairman's statement, commend the staff for their hard work on this issue. I was in Scranton last week for their rollout there. They have outreach in Johnstown, Philadelphia, and Pittsburgh also. These events are well respected and attended by social service agencies, utilities, and our staff to really get ahead of these issues. These issues matter. We have a lot of struggling residents, a lot of struggling communities, an aging population, a income-limited population in many places. Getting out early, getting ahead of these issues, getting weatherization done, coordinating between social service agencies and the utilities. And when you see it on the ground, it does very much matter. And for that, I would commend all involved. So thank you.
Okay. Thank you very much. And with that, the meeting is adjourned.